where we are learning new developments in the ever-providing Karen Read case. Her murder retrial will begin on April 1st, and she stands accused, as you may know, of killing her Boston police officer boyfriend, John O'Keefe, by hitting him with her SUV and then leaving him to die in the snow. Joining me now in studio with all the latest is our own Court TV crime and justice correspondent, Matt Johnson. Great to be with you, Matt. Every time you come, there's something new, some new development. So, latest news about Aiden Kearney. Tell us.
Yeah, you know, this is part of the flurry of motions and the rulings that Court TV received earlier today. The judge in Turtleboy's case is allowing the Commonwealth to access cell phone data, pictures, and text messages between Aidan Kearney and Karen Read between April 8th and October 5th, 2023, that window. That's what led to this dramatic moment yesterday. Remember this, Judge Ashley, when Karen Read and her defense team stormed the courtroom mid-argument by Special Prosecutor Hank Brennan in Turtleboy's case. Read's team told the judge there in that case that the hearing was, quote, bizarre, and that she had a right to be there because that hearing was called under her criminal case number. Brennan said that he wanted Kearney's cell phone data connected to the allegations of witness intimidation of key witnesses, including the McCabe's, Alberts, and Proctors, not to prove witness intimidation by Karen Read, which she has not been charged with, but to show consciousness of guilt in her case.
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Read's team.
I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time.
Judge Beverly Cannoni will have to decide if the jury in the retrial can hear about these messages between the two, Karen Read and Aidan Kearney, which her trial is still on track for April 1st. Aidan Kearney is also on the state's witness list, which is a bit different from the first trial. Remember, he's a blogger that really, by a lot of people's accounts, put a spotlight on this case from the beginning. He's not going to be allowed in the courtroom during trial number 2 or to be able to watch the proceedings on Court TV because he's on the witness list, so that's a big change this time around.
That's a big change, and I wonder, Matt, sometimes strategically a witness list is done for not only those people that might be called as a witness, but to keep them out of the courtroom, quite frankly. So I'm not accusing the Commonwealth of that, but I can say I've seen it done in some cases. Every possible witness has to be on the list or else they can't be called.
And you know what, that's an interesting point that you make too, because of the 10 seats that are granted to either bloggers or members of the traditional media and Court TV, we stand right behind the O'Keefe family and some of the witnesses in the case. So it's a very intimate courtroom, as you know, and that would prevent him from being in that back row.
Ooh, this is such good insight. You've spent so much time there. You know very well what the courtroom is like. Now, I've learned something I'd love for you to help us understand, because I'm surprised that the Commonwealth, as I understand it, is also now seeking text messages between the defendant, Karen Read, and one of her own attorneys.
Yeah, David Yannetti, who she hired from the get-go, and he is the one that is not pro hoc vice, right? All the other attorneys are on his license. He is the licensed attorney in the Commonwealth of Massachusetts. She hired him from day one. So the Commonwealth wants communications between Karen Read and her first attorney that she hired, David Yannetti, saying that all her interviews waives her attorney-client privilege. Prosecutors quote Karen Read from the recent HBO Max documentary in their court filing that says this, and I'm going to read it in part. And this is a statement from Karen Read. And then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if? I don't know. What if I ran over his foot, or what if I clipped him in the knee and he passed out, or when he went to care for himself, he threw up or passed out? And David said, yeah. then you have some element of culpability. So that's how I thought about things in the first 3 days. So the court document then goes on to say this. Attorney Yannetti's statements to the defendant are admissible pertaining to the defendant's state of mind. It then reads, statements are relevant to challenge the defense's later purported claims of third-party culpability.
What we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself.
Well, the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. And I have a lengthy argument prepared detailing the evidence against each of them.
Defense has to make a decision as to what you intend to provide me so that I can make this ruling.
Okay, so jury selection is set to begin April 1st, and there has been an added hearing on the docket, Judge Ashley, next Tuesday. Some of the things that we just talked about might be argued in open court because now there's another motions hearing.
Oh, this case is something else. All these motions hearings, zealous advocacy by both sides. I feel like, though, that this judge is pretty adamant at this point in time. This trial is going to start on time as scheduled in April. What are your thoughts?
Judge Beverly Kearney has made it very clear and told these attorneys that she wants this case to stay on track and she wants jury selection to begin April 1st. That's despite the defense and their multiple attempts to delay this trial. They argued that yesterday in court. Judge Beverly Kearney denied it once again. She said no delays in this case because it takes so long to find a decent jury pool. We're talking probably more than 1,000 people in this small community that are going to have to be voir dired. That's probably going to take between 1 and 3 weeks. If we get to a point a couple weeks down the road after jury selection has started, Judge Beverly Kearney will take it under advisement once again whether or not to halt the proceedings, because what the defense is saying is we shouldn't impanel a jury before we get a decision from federal court because they are appealing the decision about denying relief from 2 of the charges.
Right.
And they want to make sure that she's not going to have double jeopardy once a jury is impaneled, because then the case will be dismissed altogether.
And I have to say, I really appreciate this judge. She does what she's supposed to do. She manages her courtroom. She lets the attorneys know where she stands, what her ruling is, and what she'll take under advisement.
She's pretty firm.
Yeah, and I appreciate that. Matt Johnson, thank you so much, as always, for all those many details on the Karen Reed case. Now let's bring in our guest for this hour, criminal defense attorney Julia Jane. Julia, so much to talk about. You know, the first thing I have to mention is one of the last things that Matt was filling us in on, and that is a request by the Commonwealth of correspondence, text messages between Karen Reed, the defendant, and one of her then retained attorneys. Attorney-client privilege. I mean, it's pretty straightforward. There could be an argument perhaps that happened before he was retained, but even so, where do you land on that piece of the request by the Commonwealth?
Well, you know, the initial reaction is, of course, that this is attorney-client privileged. It's, you know, fundamentally protected. Those types of communications should never be disclosed. However, there is such a principle as waiver. Somebody can waive their attorney-client privilege. And the real question is, by making those statements about her conversations with her lawyer, did she waive the privilege? And if so, did she waive it for all of their communications, just a limited scope? That's probably going to be part of the litigation and the decision by this judge. And while instinctually I'd like to say, well, it's, you know, attorney-client communications, it sure looks like she put it out there that these are my conversations with my lawyer. And now she perhaps has opened that door at least a little bit.
Yeah, I think you're right. And I feel like the Commonwealth is really leaning in with this special prosecutor to trying to look at the intent and how she was thinking, feeling, what her thoughts were, the consciousness of guilt. But also I want to listen together, because there's another argument being made, and these were being made about John O'Keefe possibly breaking up with Karen Reed. Let's listen to that together, and I'd love to come back to you.
We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. And it is clear, based on that and other testimony, that he was in the course of attempting to end the relationship with Miss Reed.
That's preposterous. the idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him.
And that goes to that motive, Julia, when there's, evidence of he broke up with her. I think the state, Commonwealth rather, just can add to their argument that she was a scorned woman, that she was angry, that she backed her car into John O'Keefe, and that she murdered him. Motive isn't an element of a crime, but how important is it to you, in your opinion, for a jury to convict or not?
I think a jury always wants to know about both motive and lack of motive. You're absolutely right. It's not an element. It doesn't have to be proven beyond a reasonable doubt, but it's human nature to want to understand what happened. And that's why it's just as important for the defense to take on that motive, rebut that possible motive. The question is, was she aware that he was going to break up with her? And is that enough to go from, that I'd rather see you dead than be broken up with you? I think that there's some leeway for the defense to really rebut if that is the only motive, that you would kill someone rather than be broken up with. And what evidence is there to support that she was even aware of that, and how far had that gotten? So if you ignore it, I think you're doing your client a disservice as a criminal defense attorney to just ignore that, the motive that's been put out there by the prosecution. You have to take it on, and you have to think about what witnesses or rebuttal evidence or even cross-examination you're going to do with respect to what your response to that alleged motive is.
Yeah, great information. Things for our viewers to think about. Julia, stand by. I want to now welcome who is joining us, Tim Bridl, Aiden Kearney's attorney, Turtleboy, as many know him. Tim, I can't thank you enough for joining us today. I could talk to you all day about the legalities. I've read your motions, I've read your blogs, but let me start with this, because to set the table again for viewers who might just be joining us, the court did order that the district attorney's office is to release to the Commonwealth limited information, but it's information that's between your client, Turtleboy, and the defendant, Karen Reed, that has to do with witnesses. So first of all, your reaction to that court order ruling?
Yeah, Judge, it's a tough one. It's a real intrusion into journalistic integrity and privacy. We're not concerned about it, though, because there's really nothing there. It's a big nothing burger as far as we're concerned. There's no criminality. There's no communications that can serve as the basis for anything we're concerned about. What's most troubling, though, is the notion that the government can say, we know these people are talking and we want to hear what they're saying without any sort of underlying crime that they can allege. And there's an anomalous situation here where the very conduct that they're trying to rehash and recycle here as a basis has been rejected by a grand jury, and no indictments issued against Ms. Reed on this exact evidence. So how can they use this evidence again to get another bite at the apple to try to get into Mr. Kearney's phones? That was our argument. The judge felt that since the government had it already, it wasn't a big deal to give it over, I suppose, but it is a big deal. And that's troubling. But in terms of the evidence in the case, we're not too concerned.
So in terms of the big deal, to me, it's that slippery slope that as attorneys, we're all trained to be cautious of, right? And so if this information, even though the judge limited it based on what the Commonwealth initially requested, they wanted, as I understand, everything between the witnesses or about the witnesses from your client. And then the judge said there's no relevancy there. So instead, I'm going to narrow that and say it has to be communications between the defendant and your client, Turtleboy. But having said that, there's still a slippery slope that I think if this comes out this time, if this gets to be released this time, what about next time? Is it going to apply to everybody who's doing this type of work, who's blogging, who's a journalist? And is it going to start to include more and more and more information that should be protected by privacy?
I'm so glad you said that, because we really don't get a lot of that type of sentiment from the mainstream media, with some very good notable exceptions here in Boston. But yeah, that's the next domino to fall, is that they should not be able to just say, hey, we heard these people were talking. We want to see what they have to say without being able to establish any sort of probable cause for criminal activity. Again, the grand jury rejected that. So what are we doing here is our position. And, who's next is what I keep saying to our local journalists here every time. I say, you guys should be holding signs and yelling and screaming too, that you're next if Aiden's journalist source material and investigative avenues are able to be, pried into by the government. That's a pretty scary proposition without an underlying crime.
So the grand jury didn't find a crime, and I understand your point there. And I guess I wonder, is there any sentiment by you that the Commonwealth is trying to backdoor it? Because here's what they've argued in this case. Before this other judge, it was a different judge who had to make this ruling, but they're saying instead now this is consciousness, I can never say that word well, embarrassing to admit on national TV, but I will, of guilt of the defendant, that's the way they're coming at it now, and I guess in part we're successful.
Right. Well, when this search warrant was made public back in February of 24, Aiden and I and Mark, we really didn't have a dog in the fight. And I was just compelled. I was so surprised that they were able to get Karen's phones just because of these sort of transparent, these basic things like her allegedly saying, hey, keep this private. Let's keep this between us. Don't share this, as if that was somehow criminal. And, she's a woman who's charged with insanely overcharged, by the way, with murder in this situation. And the government's facts are just absurd and just don't support that at all. But, she's entitled to defend herself, and she's entitled to talk to anybody she wants, to marshal the evidence anywhere it goes, to try to spin things, to try to get public relations out there the way she wants it. She's allowed to do that. That is not a basis for a crime. The only thing she's doing here is trying to keep confidentiality. That's the only thing they had. And it's chilling that they cite that in the search warrant and to the court as evidence of a crime, that people want to keep things confidential. People want to talk to each other about investigating things. All of a sudden, it's evidence of a crime, I suppose. It just gets worse and worse and worse in Norfolk County, Massachusetts. But we're going to put a stop to it. I have no doubt.
And one of the things that stands out to me, I was actually looking at one of your blogs. This was back from February 1st of 2024. And in that, Tim, you said about this particular case and unsealing the search warrant, the only crime here is the robbery of privacy. Do you still stand by that?
Absolutely. It just gets worse. They think that the government's desire for evidence is all they need to just say, hey, we want to see what they're saying. The case law in Massachusetts, Judge, is such that, you can't get into a cell phone under the general proposition that, hey, we all have a cell phone in our back pocket, so you must have been using it in terms of this crime. You need an underlying crime. And the case law, it's Commonwealth versus White, says that you need a nexus between the device you want to search and the crime. And here, they don't even have a crime. There's nothing criminal about wanting to speak privately and defend yourself and criticize witnesses that you think are dubious. It's absurd.
But it does. Let me push back on that a little bit, because if the court, which the court has now narrowed it in the order and said it's communications between your client and Karen Reed, the defendant, who is charged with murder. I know that we're divided. Some people think she did it. Some people think absolutely not. A very divided country watching this case. But having said that, I think that it's a good argument by the Commonwealth that this gives insight into her that they can use as evidence against her potentially in the trial, that they say, hey, she backed up and she ran over and she murdered her boyfriend.
So it's still that chilling proposition that someone's communications, where they're trying to maintain confidentiality, criticize witnesses, talk back and forth about witnesses, that can be used as evidence of consciousness of guilt is absurd. You can't take someone's efforts to defend themselves and say, ha, look what you're trying to do to these witnesses. You're guilty. What is she trying to do to the witnesses? Investigate them, criticize them, look into them, talk about them? Since when is that consciousness of guilt?
I will say, we know, and I think you would agree with this, that every prosecution I've ever seen is going to try to use defendants' words against them at the end of the day. And I think this is a great example of that. Let me just ask you one more question. The order that I've reviewed that we're familiar with, where the court says this has to be produced by the DA's office to the Commonwealth prosecutors that have requested it. Do you intend to protest or appeal that, or are you agreeing to comply with the order or not stand in the way of compliance? It's not yours to comply with, but are you going to let it move forward?
Sure. We talked about a potential appeal, but, you know, like I said, it's a nothing burger. There's nothing there that's going to hurt anybody. And, you know, we have so many things to do on Aiden's case, and the Reed defense team obviously has so many things to do on their case. We really just don't have time to kind of stand on the principle of it right now. It's not going to hurt us. We're going to circle back on some of these incredibly weighty First Amendment issues, and we really want to get to the SJC, the Mass State Supreme Judicial Court, and get some rulings on, first of all, the witness intimidation statute, which is an absolute abomination, completely unconstitutional in about 10 different ways. And it just has not really been put through the rigor of a SJC appeal, and we want to be the ones to do that. And we're very confident that that statute is going to be blown up in the state. And also, I want to tell you that one of our state reps, Nick Boldiga, has filed a journalist protection bill in the state legislature that's just come out. And I really hope that's going to be brought through the process and become law very soon. That would put an end to all these kinds of insane government overreach into journalists' business.
And this is a great way to see how we work on getting new laws, right? This is the process, and this is why laws change and why laws get written. Tim Bridl, I can't thank you enough for spending time with us. Thank you so much. We hope to have you back.
Thank you.
All right.
Thank you, Judge. Take care.